welcome back to my channel. My name is Joanne. I hope you're doing really well. So today there was another court case, an appeal. Actually hasn't been leave for appeal, but there is an argument over some evidence that they would like to use for the appeal. Today there's a 2-day court today. There's 2 days of court argument over an 85-second audio clip. So the first part of the day was arguing whether it could be admitted, and the second part of the day was about the audio clip. So let's just sort of where we are. So this is the appeal for the Ben Robert Smith appeal against the court's decision that the media did not defame him when they alleged that he was possibly a criminal. And the media agencies had pled the truth defense, and on the balance of probability, evidence shown indicated that his actions could imply that what the media said about him was correct. So we had two sides. We had the Ben Robert Smith side, and we had the it's Fairfax. I think it's Fairfax Media and Anor. So Fairfax Media, knowing that it shouldn't be admitted. So there were two main court legislation, or two main points of argument. So we need to look at the against. So let's look at the against. Okay, the against used two types of legislation. So there's the Uniform Evidence Act of 2008, which is a national act. And they use section 1385 and 138. So discretionary and mandatory exclusions. So they use 135, which stated the court may refuse to admit evidence if probative value is substantially outweighed by the danger that the evidence might be A, be unfairly prejudicial to a party, B, misleading or confusing, C, result in an undue waste of time, D, may demean the decreased in the criminal proceeding for a homicide offence. So that was the section. So what they were saying was that there was not enough of this to be of any value. We're talking about 85 seconds of evidence of a phone recording. They were saying, so it's edited evidence. It was agreed on that nobody knows who recorded it. They don't know who recorded it, or who sent it to the lawyer. It was anonymous. And so they were saying that was probative value. And their second argument was that it was improperly or illegally obtained evidence. So evidence that was obtained improperly or in contravention. So they were using this. Now, where the get side came a little bit unstuck with this was the fact that it was recorded in Queensland. And Queensland, every state bar Queensland, you are not able to record phone calls. However, Queensland has this act called the Invasion of Privacy Act of 1971 that was recently updated, and the section here that they all relied upon. So there is reference prohibited on listening devices. So there was that, but they were relying on section 45, I think. I just had it here, 45. So and the people that were that the Robert's side was talking about section 45. So section 45 talks about prohibition communications of publication private conversations by parties. A person who, having been party to a private conversation, having used a listening device to record or monitor that conversation subsequently communicates or publishes to any other person any record of the conversation made directly or indirectly by means of listening device or any statement prepared from such record is guilty of an offence against this act. And then, however, subsection 1 does not apply where the communication or publication is, and these are the exemptions. Now, the party, Ben Smith, they were relying on subsection 2D, this one. So it says, is made by another party to a private conversation or with consent expressed or implied by the parties, is made in the course of legal proceedings. They also relied on that one. Is not more than reasonably necessary in the public interest in the performance of duty of the person making the communication for the protection of lawful interests. Is to a person who has or believed on reasonable grounds by the person making the communication or publication to have such an interest in the private conversation as to make the communication or publication reasonable under circumstances in which it is made, or is made by a person who used the listening device to overhear, record, monitor, or listen to private conversation. Now, they also had a big discussion over definitions. So in subsection 2, legal proceedings include proceedings, civil or criminal, proceedings before justices, proceedings before any court, tribunal, or any part of legal proceedings. Now, 46 does talk about private conversations. So there was a whole around section 45 of the Queensland Invasion Privacy Act and the 2008 Uniform Evidence Act, particularly section 135. And that was the morning that was going backwards and forwards, like a tennis match. However, coming back after lunch, it would seem they said they allow, so it says that this is from the Financial Review, the 2-day hearing centres on an 85-second recording that appears to be a snippet of a longer conversation between Mackenzie and person 17, and that's all we know, person 17. Robert Smith, who gave evidence for the newspapers during the defamation trial and whose identity was suppressed earlier on the Thursday, ruled recording be admitted into evidence for Robert Smith's application, but that did not mean the appeal has been reopened, and that's what they're arguing about. They want the appeal reopened and this evidence to be allowed in. So it's a conversation between person 17 and a journalist. What they know is that it was recorded in Queensland, so the Invasion of Privacy Act legislation is in it, or can be used, okay? If it was any other state, it would be illegally obtained. So you've got 85 seconds. What no one knows is who made the recording or who sent it to Robert Smith's lawyer. It could have been done by a third party. So Robert Smith's lawyer was saying, heard this conversation, or this snippet of conversation, and thought it was in the public interest that it be let go. So the court said, we will allow this evidence, but we have not decided that we're going to go to reopen the case. However, the journalist in question, Nick Mackenzie, was put under the hot seat today. He was given a right old grilling by Robert Smith's lawyer. As you do, you've got to remember Robert Smith's lawyers, for all intents and purposes, want to prove that their client has been wronged in some way, and it's an appeal. The lawyers for the newspaper want to show that the journalist is correct and right, and that Robert Smith is in the wrong. So the lawyers for the newspapers, the respondents, are likely to be a lot nicer to this guy than Robert Smith is. You always remember that. When they're getting a grilling by a lawyer, you've always got to remember what is the purpose of this questioning. And they gave him a good old grilling, and you knew that he was a very experienced person in court. I would say it wasn't his rodeo for court proceedings. But this is how the Financial Review reported it. He says he feasible on this means to obtain material for his investigation into Ben Robert Smith as the disgraced soldier attempts to reopen the appeal of his defamation action over a secret recording. So Mackenzie took the stand on Thursday in the full federal court in Sydney to give evidence and face cross-examination, and he's doing that tomorrow. Robert Smith sued the Sunday Sydney Morning Herald, The Age, the Canberra Times for defamation over a 2018 article by Mackenzie Masters and David Rowe that allegedly he committed during deployments to Afghanistan. So in 2023, Justice Anthony Bozanko found the newspapers had proven that Robert Smith broke the rules of law and disgraced his country and the army by his conduct in Afghanistan. In August, he lodged his appeal, which was heard last year, and he's awaiting judgment, but he's trying to reopen the appeal. Okay, so earlier on Thursday, so as I said, could be admitted to evidence. He's being funded by Kerry Stokes, a billionaire. So Mackenzie was questioned by Robert Smith's barrister, Arthur Moses, SC, on a segue note. He is the partner of former New South Wales Premier Gladys Berejiklian. That's a bit of a segue. Arthur Moses, SC, about the Media, Entertainment and Arts Alliance Journalist Code of Ethics. In particular, the standard to use fair, responsible and honest means to obtain material. Moses repeatedly asked Mackenzie whether he applied that principle as an investigative journalist during his investigation of the Robert Smith. Mackenzie said he had. Mackenzie said he was extremely anxious throughout the legal proceedings. I was anxious to prove that Robert Smith was a war criminal, and we had to find evidence to do that. It's put to Mackenzie that we was prepared to go to lengths to find any evidence which would help in the litigation. I don't know what you mean by great lengths. I was motivated to find the evidence of truth. Earlier on Thursday, the newspapers argued the recording should not be admitted to evidence. Robert Yezerski, SC, acting for the papers, and Mackenzie argued the recording and transcript should not be admitted because it had been made without Mackenzie's knowledge or consent. So that's what I'm saying. In any other state, I think bar Queensland, and this was discussed, it would have been illegally obtained. The recording appeared to be edited. He argued it appeared to have been it had been changed and sent to Robert Smith's lawyers for maximum benefit of the former soldier and maximum harm to the Mackenzie to newspapers and Mackenzie. And that's what they're talking about, probative value. They were saying that it was designed, that 85 seconds bit is not very nice. And it's made to make Mackenzie look bad, and so it has a bias. The recording was sent to Robert Smith's lawyer on the 15th of March via a pseudonymous email system called Eroy Ferris. Yezerski said it was assumed the person 17 recorded conversation, and the recording was done in Queensland. The court, it was unclear who was behind the email, and whoever sent it may have committed a criminal offence. And that, again, is where you could talk about admissibility, because if it was obtained illegally, it can't be admitted. So this, again, this is the Guardian. And remember, he's an investigative journalist. Now, he talked about the fact that sometimes he goes undercover to get information. And the allegation they used deceptive methods. They kept saying this word, and I cannot pronounce it to save myself. What is it called? Subterfuge, which means deceit. Subterfuge. Subterfuge. In order to obtain information on occasion if it is in the public interest. So it's all very interesting. Now, what was also pointed out that there was an incident in 2010 with Mackenzie where he was charged by two colleagues for unlawfully accessing a Labor Party database for a storage that was published in The Age. Mackenzie accepted his method being unlawful, but asserted he had not crossed the line and had been upfront about the methods in the published story. Asked if he would be improper of him to access someone else's information unlawfully, Mackenzie responded that it was a very broad proposition. There are instances where it is our job to find information that has been hidden. Mackenzie agreed that once the litigation had commenced in the Robert Smith case, he continued to search for evidence which would contribute to the case. When asked if it was fair to say he was highly motivated during the proceedings to dig up anything his legal team could use because he was desperate to achieve a breakthrough, Mackenzie said he wouldn't say it in those terms. Throughout the proceeding, I was really anxious to prove Ben Smith was a war criminal, and we had to find evidence to do that, he said. He was also questioned over communications with Robert Smith's ex-wife, her friend during the litigation proceedings. 2 of those conversations were had with Scott in August 2020. The court heard were not included in the original trial. Asked by Moses if he was aware those recordings were not discovered in the trial, Mackenzie said he provided them to his lawyers and he was not aware whether they were exhibited in the scheduled as communications. The court heard that Mackenzie had forgotten that the recordings existed until the bid opened the appeal, and he couldn't recall if he kept a copy of them. At the centre of Robert Smith's bid to reopen his appeal is a secret recording made without Mackenzie's consent or knowledge, on which Thursday was ruled admissible evidence. According to an affidavit filed by one of Robert Smith's solicitors, Mackenzie, in the recordings, allegedly told a witness in the defamation proceedings known as Person 17 that Robert Smith's ex-wife and her friends were actively briefing us on his legal strategy in respect of you. We anticipated most of it, 1 or 2 things now we know. According to the affidavit, Mackenzie also said in the recording, I shouldn't tell you, I've just breached my effing ethics in doing that. The court heard that the recording was sent this year by an unknown person, an encrypted email to Paul Surveillance, one of Robert Smith's lawyers, subject line secret Mackenzie recording. On Thursday, before a panel of judges, line barrister Robert Yaszewski argued that the recording should be rejected by the court because it was recorded with Mackenzie's knowledge or consent, and whoever published it was guilty of an offence. The recording was more than likely not made in Queensland, where it is not an offence to record a conversation in private, but it is an offence to publish that recording. He also argued that the 85-second recording was a snippet or extract from a conversation that could have lasted 15 or 45 minutes. And of course, Moses, who acted on behalf of Robert Smith, argued that the recording should be admissible because there was no evidence pointing to who said the recording, how it was recorded, adding there was much that we don't know. So Moses also argued the evidence had a limited nature because it contains an admission by Mackenzie of a serious nature. So that's where we are. So the court allowed it in. And I don't know. I didn't hear their reasons. I didn't hear their reasons. I find it yeah. I mean, I think for me, I would want the whole. I'd actually want the whole. I want to know exactly what was going on, but that's just me. So let's go. I'm just going to go to the online file here and see whether we can find today's stuff. That's right. That's the old one. So that's where we are. Tell me what I mean. So tomorrow it goes again, and then they will then they'll look at it again and decide whether or not to reopen case. So which means I don't know whether that means then going to start again. I don't really know what that means exactly. This is all new to me. It's but they're trying to get the case opened, even though the appeal's been heard. They're trying to get more evidence into the appeal. And so that's where we are. And so anyway, we just see what comes about, what's disclosed tomorrow. So I'd be interested to know what you think about all of it. Can you rely on an 85-second snippet in a court case, or should the whole thing be? And because if they don't have the whole conversation, can that be? I mean, they rely on sections of transcripts of everything anyway. So, I mean, that's the other thing. But that 85 seconds is damning to the newspaper side. So it's going to take some skill, I think, to be able to argue out of it. But anyway, I'm interested to know what you think. And I will catch you next time. Make sure you hit like and subscribe for me. Bye for now.